Hello, Michigan Realtors, and welcome back to the Letter of the Law. Much like all of you, Michigan Realtors has been following the ongoing class action lawsuits centered on the negotiable nature of commissions and MLS rules. We also know there is a significant amount of anxiety surrounding the resolution of these matters, compounded by a fair amount of misinformation that has been circulating for the last several months. Now, regardless of the outcome of the NAR class actions, we felt it was important to focus on some of the best practices that protect both realtor and client during the process of buying and selling a home. The following are recommended practices to protect both you and your buyers and sellers. Number 1, always use a written buyer's agency agreement. More than sound practice, this should be viewed as an integral step in the representative process. This is a great opportunity to discuss your value proposition with your buyer client. It is also an important step whereby you formalize your role as an advocate, educating your client on the importance of having an advocate in the competitive home buying process. For a firm that practices designated agency, there is no alternative to observing this requirement. For all other firms, this conversation and the signing of a buyer's brokerage agreement should be viewed as smart business to ensure a true understanding between buyer and agent. Number 2, as part of that initial conversation, if you are a buyer's agent, never advise a buyer that your services are free. Not only is it not a true statement, but it also serves to confuse the buyer and perhaps diminish your role as an advocate. It is important for the buyer to understand exactly how you're getting compensated. Number 3, be transparent as to any cooperative commission being offered on any property. Number 4, as part of client education, remind all clients that commissions are established by contract and are not fixed, controlled, or recommended by law, the MLS, or any third party. Consider including the following language in your service provision agreements. Broker's fee for services rendered is not fixed, controlled, or recommended by law, the MLS, or any person not a party to this contract. Number 5, and finally, assure buyers that you will show them all properties that meet their criteria regardless of the amount of cooperative compensation offered. While much of what we've covered here may seem like common sense and already a practice you adhere to within your brokerage, it has never been more important for your clients to have a clear understanding regarding your role as their advocate and all the beneficial expectations that follow. As always, thank you so much for your viewership, and please continue to send us your ideas for future installments. If I don't see you before, make sure you're watching your mailbox for the new installment of the Legal Hotline Companion. It should be hitting mailboxes in mid-November. Until then, have a great fall season.